Hello and thank you for attending our webinar on licences to alter. I'm Julian and I run Earl Kendrick Associates, a firm of chartered building surveyors.
And I'm Yasmin Mystery. I'm a solicitor and partner at JPC Law, and I specialise in all things residential long leasehold.
Now between us we believe that we've experienced licences from every angle, and in this process we've met many clients and at various stages of the licence process.
Unfortunately, licences to alter is quite a dry subject. We'll try to cover the core bits that you need to know about the process and the procedure, and we'll try to keep it as light as possible.
Now we imagine that each of you has a vested interest in property. Some of you will be here today listening in to learn more about the licence process, perhaps get some answers for some specific questions. Some of you may even be completely new to licensing and have listening to this webinar to get an understanding of what licences to alter are. So to start with, I'd like to run through what we will cover in the presentation today. We'll be looking at the types of covenants, duties imposed in relation to applications. We'll run through the outline of licence to alter procedures. We'll then look at the information requirements. I'm going to speak in a bit of detail about some of the technical issues in licence applications. Yasmin will then cover some of the remedies available, do's and don'ts. I'll then talk through a typical licence report, what surveyors produce as part of the licence review. And then we'll talk about some of the issues that occur when the work's on site, monitoring and commencement. So I'm now going to pass over to Yasmin, who will start with looking at what the definition of a licence is.
Okay, great, thanks Julian. So when you are presented with an application for a licence to alter, whether you're acting for a landlord or a management company who's party to the lease, the key before you can proceed with a licence application is the lease. You've got to see the lease, you've got to understand what the lease says in relation to licences for alterations. Generally, the lease will have three different types of covenants. The first one is an absolute covenant, the second one is a qualified covenant, or the lease could have a fully qualified covenant. So looking at each of these in turn, an absolute covenant will prohibit alterations absolutely. So only if the landlord decides that he wants to waiver the clause in relation to the alterations will the tenant be able to undertake the alterations. So for example, a sample clause in a lease may be that a typical one will be that the lease prohibits structural alterations completely. That's a usual one that we come across. The next one is a qualified covenant. And if I could ask Julian to turn the slide, great. So a qualified covenant is a covenant which prohibits alterations save with the landlord's consent. So what that will look like in a typical lease will be the tenant's entitled to do structural alterations with the landlord's consent, or another example will be the tenant's entitled to do non-structural alterations with the landlord's consent. And that's where the tenant would have to make an application to the landlord, and the landlord would consider whether or not to grant consent. The third covenant is called a fully qualified covenant. And that is where it would say in the lease, an alteration may only take place with the landlord's consent, and that consent can't be unreasonably withheld. That's what it would normally look like in the lease, and most of the leases these days contain those kind of covenants. So that's the lease. That's in relation to covenants. But a question that we're normally asked is, what happens if the lease is completely silent? What happens if the lease doesn't mention alterations at all? In which case, your clients or the landlord or the management company, whoever your client is pretty stuffed, unfortunately. If the lease is silent in relation to alterations, a tenant is free to carry out those alterations as it chooses. They don't have to obtain consent. Consent generally, on qualified covenants, consent can't unreasonably be withheld. That means, and we'll look at what that means later on in the presentation, but basically the landlord has to give due consideration to the application, and he has to give a reasoned and logical reason as to why consent should be granted and on what conditions, or whether consent should be refused completely. So what happens if the landlord refuses consent? The tenant has two options really. The tenant, if he feels the landlord is unreasonable in arriving at his decision, can make an application to the court for a declaration that the landlord's been unreasonably withholding his consent, or the tenant can just carry on with the works without the landlord's consent. That's risky on the tenant's part, but as Julian and I have experienced, that's probably what most tenants would do. And then they would have to make a retrospective application for consent.
I think a lot of the issue there, where we experience tenants proceeding with the work without a licence, it's usually down to a misunderstanding. In some cases it's naivety, in others it's
pure blatant disregard for the landlord's policies and the lease.
But we'll come on to the understanding and the processes a bit later on.
Okay. So moving on to the next slide, when can a landlord reasonably, what considerations, looking at the considerations the landlord can take into account? Financial loss alone is not a good enough reason for a landlord to refuse consent for the works. The reason being is that the landlord can impose a condition in the licence and ask the tenant to pay compensation for damages to the reversion or his interest in the freehold. Most of the landed estates that I've come across in central London will usually ask for a premium for doing some works where, structural works where the demise is going to increase, or there's some kind of damage or detriment to the reversionary interest in the freehold. Another condition will be the payment of legal costs, surveyors' costs and other expenses, and that is another condition that landlords can impose in licences. There has been case law which has said that a landlord needs to deal with the payment of legal costs as part of the licence process, and sometimes landlords will refuse to deal with an application for consent if an undertaking hasn't been obtained. Unfortunately, there's case law which says because you can make it a condition of the actual licence, just because a tenant hasn't given you an undertaking for costs at the beginning doesn't mean that you just stop or you've refused to deal with the licence application. Another condition that's usually inserted into licences is the requirement for the tenant to undertake to reinstate the property back to its original state and condition, i.e. before the alterations were done at the end of the term.
Just to add that, yes, as well. I mean, I've seen in the years I've been dealing with licences that in some cases landlords don't provide consent because they just don't know how to. They're not familiar with the process, and that happens a lot in smaller buildings where there's perhaps not a retained solicitor or surveyors.
Yeah, so it's important to get surveyors and solicitors effectively on board, either quite early on in the process or at least consult them, because you will unfortunately consent needs to be considered and consent can't be withheld unreasonably, otherwise you will see yourself defending proceedings for a declaration that consent's unreasonably withheld in the county courts.
Okay, so what I'd like to do now is Yashmin's covered the legal definition of a licence. I would like to cover what happens with a licence application. What are the steps that should be followed? There's a document that's uploaded which is a flow chart. This is a document that we've put together, and this is our opinion of how licence applications should be dealt with. This is based on experience and how most agents and directors of RTM companies deal with licences. So that should be on your screen now, and I'd just like to summarise the key steps. So first of all, in most instances, the leaseholder undertaking the work will contact the managing agent and advise the managing agent, perhaps the directors of the RTM Direct, that they intend to carry out works. Some managing agents that we work with have a standard licence application form. This is sent to the leaseholder. This is then filled in with a perhaps description of the works, indication of timescales, etc. Usually the managing agents will then refer the application to a surveyor if there is a surveyor appointed, and the reason for this is that somebody needs to just undertake a review of the application and determine whether the works do require a licence. Of course, this necessitates reviewing the lease, determining what the clauses are. As Yashmin said, if the lease is silent, then it's possible that the application or the works package does not need a licence. So many leases contain clauses that restrict structural alterations, perhaps installation of hard floor finishes. So if the works involve those types of alterations, then usually a licence will be required. If consent is required and the landlord surveyor is appointed by the RTM company, the landlord surveyor would usually then obtain an undertaking of fees from the leaseholder that's carrying out the works, and then a process of a dialogue is open between the surveyor and the leaseholder, and the surveyor usually arranges a meeting on site to talk through the proposals and really ensures that all of the information that is required to accurately assess the works are handed over by the leaseholder. So in many instances this process or the surveyor's role is to guide the leaseholder through the process. So clearly summarising the types of documents that are required and the likely timescales involved.
I'm sure, sorry, just stepping in there, I've seen a whole range of, and I'm sure you have, a whole range of applications that are made by tenants. They could range from sketches on a blank piece of paper to really detailed ones. So, I mean, it just depends on, it makes your life easier if the application or the managing agents have got a procedure in terms of application forms and things.
Yeah, I mean, I had an application once and it was a range of photos of the existing flat and a range of photos of another flat that's completely different, and they said, well, we want to turn this to this, and that was the application. So again, it's just an lack of understanding of what's required. Yeah. So part of the surveyor's role is to guide the leaseholder through the process. So then there's a process of review. So we meet on site, we go through the technical aspects of the work with regard to the lease conditions, perhaps also the building regulations, because many buildings have their own licence regulations and manuals, rules for leaseholder works, and we'll come on to that a bit later on. So our role at this point is to check that the works are technically suitable. Our role is to ensure that the works will not have a detrimental impact on the freehold interest, and also to ensure that the works are undertaken in accordance with statutory compliance, building regulations, etc., etc. Usually through this process some design changes are made. For example, method of working, if structural alterations are to be undertaken, we may, or usually a landlord's checking engineer is appointed, and sort of conditions may be applied to the leaseholder on the way the works are to be carried out, perhaps access routes into the building, methods of temporary propping, etc. When the surveyor is fully satisfied with the proposals from a technical perspective, then we will produce a report that is then sent to the directors of the management company and the managing agents, if there's a managing agent appointed. And as I touched on earlier, so if the works are extensive, perhaps involve structural alterations, then there may be a necessity to appoint other consultants on behalf of the landlord. The typical consultants are a landlord's checking engineer if there are extensive structural alterations, if there are extensive alterations to building services, perhaps communal heating systems. The landlord may be well placed to appoint a checking engineer, and another typical a consultant is an acoustic engineer. So if the leaseholder is intending to install hard floor finishes, perhaps installing building services that could create noise nuisance for other flats, then the landlord may require some assurances from a consultant appointed on the landlord's team.
Just stepping in there, Julian, a question that I normally come across once the whole process has been reviewed by a surveyor, and questions from tenants and tenant solicitors are, does a landlord really need to have people appointed on his behalf? Could a joint surveyor or a joint checking engineer or a joint acoustic sound checking engineer, could they be appointed? That's the question that we normally get asked. So
yeah, and I think in some instances it's entirely suitable for perhaps the tenant structural engineer to provide the landlord with a warranty to avoid a duplication of role and fees. I mean, the key thing is that the landlord's consultants are generally appointed on a checking basis, so they're not repeating the work. And typical ones, I mean, I've seen tenants engineers putting forward proposals based on a number of assumptions. Unfortunately, assumptions can be the cause of problems. So the landlord's engineers are very usually very robust in making sure that any assumptions are discharged. Typical ones are ensuring that access is available to flats above to bottom out any assumptions.
I think, the other thing is that you need to bear in mind, acting for landlords or management companies, is it's all fine having joint people appointed whilst parties are getting on, the works need to be done, everyone's happy. It's when the landlord surveyor points out things which are having a detrimental effect on the freehold, effectively, or the landlord's property. That's where issues arise, and that's why it's probably better to have the independent checking engineers and surveyors instructed on behalf of the landlords, really.
So at the point of submitting our report, that's reviewed by the director of the management company. Possibly some dialogue, questions are raised, clarifications, and really some additional information may need to be provided to provide assurances to the directors. When the directors are happy in principle with the proposals, the landlord's solicitor is then instructed to prepare a draft licence. And this is Yashmin's domain, which you'll come on to a bit later. So that licence is prepared by the solicitor. This is usually then sent back to the directors, the managing agent, the landlord surveyor. All parties really should look through the document. I think we've worked together on a number of licences, and we find that as a very robust checking procedure that the terms of licence mirror the recommendations that we put in for the terms of the consent. When the draft licence is approved, that's then sent to the leaseholder's representative leaseholder, perhaps a leaseholder's solicitor, for signature. In some instances, there's a process of comments on the draft licence, but generally that's reviewed by the solicitor, signed. When the licence is signed, the works can then commence on site. Usually in the licence, there's a number of conditions that need to be discharged before works commence. Typical ones are perhaps schedules of condition, obtainment of the leaseholder's appointed contractor's insurances, perhaps method statements for access arrangements. What I do find is that sometimes the licence is issued, it's signed. The moment the licence is signed, work start on site, and the guys on site don't really have any regard to the content of the licence, so there's sometimes a breakdown in the communication. So on particularly large buildings or complicated licences with a number of conditions, what we have introduced is a pre-commencement certificate, and this is an additional step in the licence. Not an onerous step, but it just again provides the landlord with assurance that the requirements of the licence are discharged. A pre-commencement certificate, typically a tick sheet that covers whether, as I say, the schedules of condition, the insurances are in place, etc., etc., etc. When the pre-commencement certificate is issued, the leaseholder is then free to start with the works.
Is that the works, the whole works, or just the stripping out works, or the stripping out works? Is that before the pre-commencement?
Yeah, it's a good question. I mean, we work with a number of buildings. I mean, some buildings are quite happy, or some directors, should I say, are quite happy for strip out works to commence. I mean, again, it depends on the extent of the works, the terms of the lease. Mm-hmm. In my experience, once strip out works commence, it's very difficult then to stop a contractor from continuing with work. So there's a gumption on site to just crack on. So if strip out works are permitted ahead of any licence, then that really needs to be again, depending on the lease, almost a separate consent with conditions that make that part of the works well controlled. In some instances, it's of course necessary to carry out or permit some exposing works, particularly in structural alterations, where engineers might need to dig holes in walls to see what's going on in the building. And again, we give certain conditions for that work. So I've covered the general procedure for the licence application from the point of the application up to the commencement of the works on site. There's another document that should be on your screen, showing on your screens now, which is a checklist of the items that the surveyor will look at as part of the licence review. I'd just like to touch on some other important points. As I mentioned earlier, once the surveyor is asked to act on behalf of the landlord, it's vital that there is an undertaking of fees obtained from the leaseholder undertaking the work. Some managing agents will take a deposit for professional fees. Some clients we work with request that we contact the leaseholder direct and give an estimate of our time and again obtain a direct undertaking. At this stage we always provide an estimate of the amount of time we expect to take in reviewing and reporting on the works. Obviously that's following the initial review of the information we've received. Of course, it's always important to ensure that the leaseholder or the applicant is the owner of the flat, of the apartment. We've had instances in the past where applications have come in, and we found out that the applicant isn't the leaseholder; they're potential purchasers, and that can sometimes they can fall away and sort of waste of time.
On the flip side of that, for managing agents, it's also important to know who your client is and what relationship they have in the lease. Obviously, with the older leases where it's just two parties to the lease, so the freeholder or the tenant are parties to the lease, then most of the time your client will be the freeholder or the landlord. Sometimes with the more modern leases, the tripartite leases, where you've got three parties to the lease, and sometimes, it depends on who your client is. You need to double check who your client is. Some leases require the freeholder or the landlord to give consent. Some leases require just the management company to give consent, and some leases require both. And also where you've got more complicated title structures, where you've got freeholders, intermediate landlords, superior landlords, you need to double check who the consent needs to come from. We've had occasions where, on licences that we've worked together, where we've had a freeholder and an intermediate landlord, and obviously each of those parties are entitled to, or should be entitled to, instruct their own surveyors and their own solicitors to review the documents. So it's important to work out who your client is and what consent they should be providing, if any, under the terms of the lease.
Another point, sometimes we receive extensive packages of information that may have a significant impact on the freehold interest. Typical works are rooftop developments, perhaps a leaseholder in a top floor apartment intending to build a penthouse on the roof. I've had one recently where a leaseholder is intending to buy part of the communal roof space and build a roof terrace. So what we do in those instances is, before we undertake a full review and start incurring time and expenditure, we discuss the proposals with the freeholder and obtain some direction in principle, because if the freeholder is not going to permit a rooftop development, there's a pointless exercise in reviewing all the information to come to that conclusion. As we touched on, the quality of the information provided at the application stage is key. It's essential that the package of information is comprehensive and clear, that we're able to fully assess the proposals. It's also essential that those documents are clear and concise, because they will ultimately form part of the enclosures in the licence. And we regularly get varying degrees of quality of information, as I said. So what we like to do is, at the start of the review, we send a very clear summary of what we expect in the package of information, even in terms of drawings. Ideally, drawings for existing and proposed should be at the same scale, so it's easy to overlay the drawings, etc., etc. I won't go into detail now, but again, there's another document in the package that just lists out what our requirements are for documents to be submitted as part of the licence application. So I'd just like to touch on some of the matters that we assess. Again, these apply to the majority of licences. So we will undertake a review and determine whether the proposals require planning approval, listed building consent. Typical works could be replacement of windows, perhaps penetration through external walls for new bathroom ventilation, installation of air conditioning. We look at whether building regulations are required. So again, structural alterations, changing of drainage pipes. If the works do fall under building regulations, then we like to see the application that has been made, and we like to obtain confirmation from the leaseholder that they understand that the works need to be carried out in accordance the current building regulations. In the case of structural works, we obviously need to see the leaseholders, structural engineers package of information, which should comprise initial investigations, a report on the impact of the proposals, details for structural alterations and calculations. And again, as I touched on earlier, we like to see what assumptions have been made. We may recommend that the landlord appoints a landlord's engineers, as we've discussed. Another important point is that we regularly see engineers providing information, but then with design liability for temporary propping on the contractor. And then again, that's sometimes a weak link, because the engineer is not then involved in the temporary propping. If the temporary propping is defective, that's usually often what can cause damage in the building. So we always like to ensure that the structural engineer, whether it's the landlord's engineer or the tenant's engineer, is approving the contractor's temporary propping and temporary works. We look at the wet areas, and wet areas we refer to bathrooms, kitchens, utility rooms. In the last 10 years, there's been a move towards creating open plan spaces, open plan living. So, commonly leaseholders are intending to or wishing to relocate the kitchen, perhaps take down walls separating kitchens and reception rooms. So we look at what the alterations are to the wet areas. Some buildings that we're involved in prohibit the relocation of wet areas. So, for example, turning a kitchen into a bedroom, perhaps then putting the kitchen into the reception room. Some buildings control the relocation of wet areas, and the usual condition is that if a wet area is being relocated to a dry area, and the area below the dry area is already a wet area, then that is something that would be considered. As I said, some buildings just have an absolute prohibition on relocation of wet areas. And of course, the issues are potential for leaks, potential for noise nuisance, and just potential for disturbance. A kitchen over a bedroom is likely to cause nuisance to the flat below, particularly if
the washing machine goes
in the middle of the night. Again, at the time of comprehensive refurbishment, what we like to see is a system of waterproofing in the wet areas. The incidence of water leaks in blocks of flats, as I'm sure many of you know, is high, and this affects insurance premiums and general disruption to leaseholders. So if a comprehensive refurbishment is being undertaken, we like to encourage the leaseholder to install systems of waterproofing, and this, such a system is a continuous membrane across the floor of the wet area and turned up the walls. I mean, this won't stop a significant flood, but it will help to mitigate any leaks, perhaps a washing machine leak, or somebody drops a bucket of water. Again, it's difficult to enforce because it's not an absolute requirement of the licence. It may be included in a building's regulations manual, but it's. I mean, most leaseholders now and their contractors would do this as a matter of course. It's not expensive, and
becoming more standard now.
The leaseholders that resist are we sort of questionable, really, isn't it?
The next one's a big issue as well.
The next one's a big issue. Replacement of carpets with hard flooring. I would say on 80% of the licence applications we receive, this is an item of work that is undertaken. There's a lot of case law on this topic. There's a lot of requirements. The key principles really are that many leases prohibit the installation of hard floor finishes, timber, tiling. Some leases permit hard floor finishes in kitchens and bathrooms, subject of course to whether those particular rooms have been relocated. Hard flooring has the potential to create noise nuisance. Now, noise nuisance from footfall, so the tapping noise on the floor creates airborne noise, and the impact noise on the floor can create what we call flanking noise, so noise travelling through the structure. The usual rule of thumb is that some buildings will permit the installation of hard floors if it can be demonstrated that the new hard floor or the acoustic performance of the new hard flooring does not worsen the existing performance and meets the requirements of the lease, i.e. usually carpet and underlay. Now, many acoustic consultants are of the view that meeting lease requirements such as carpet and underlay with hard flooring is very difficult. What we suggest is that a acoustic test is carried out of the existing situation, so the existing flooring. We can then assess the performance of that floor. The acoustic consultant then puts together a detail for what the new floor makeup should be to ensure that the existing performance is reached. And then once the work is completed, a post-installation test is undertaken. And the post-installation test is undertaken to demonstrate that the new floor performs at least, to the performance of the existing floor, and really to ensure that the works are being carried out properly, because very minor defects in the workmanship can compromise the acoustic performance of the floor. Another document that is uploaded here is the recommendations for dealing with hard floor finishes in residential blocks of flats, and it's a very detailed area of licensed work, and it's probably worth just reading through that document.
I think from a tenant's point of view, the arguments that are normally thrown back when we do put the pre and post acoustic tests requirement into the licence is that to improve, you've then got the arguments that hard floor acoustic testing is going to improve, is an improvement within the development, and the lease only requires carpets and hard flooring. However, on the flip, we have seen tests which have produced better results than with the hard flooring than with carpets and underlay. I remember a couple of weeks ago we had one of those. So yeah, it's a hot topic in licences at the moment, and probably a lot more to come in the future.
Yeah, I mean, another important point is that many leaseholders, many contractors, and even consultants look at the requirements of the building regulations as a benchmark, and actually the building regulations requirements are such that they do not guarantee that there will not be any issues of noise nuisance, because the lease requirements, i.e. carpet and underlay, are usually above the requirements of the building regulations. If consent is granted for hard floors, it is usually on the proviso within the licence that the landlord has the right to ask for the floors to be recovered, or actually the tenant has an obligation to recover the floors in the event of any reasonable complaint. How enforceable that is open to and
it's also got to
debate.
Be a reasonable complaint, because I mean, we've come across instances where a leaseholder is complaining just for the sake of complaining, really, that someone else has installed hard flooring. So it's a difficult one, and it's something that needs to be balanced between the interests of the freeholder, obviously, and the interests of the tenant and of the other occupiers and in the building, really. So
not meaning to labour the point, it is a hot topic, but there was recent case law actually in the last couple of weeks. There is a case where the leaseholder of a flat that was affected by noise nuisance of a hard floor actually did seek to ask the leaseholder who installed the hard floors to recover. I think the court found that the provision in the licence for recovering the floors couldn't be enforced, because this particular circumstance, the hard floor sat above a new underfloor heating system, and I think the court found that if the floors were carpeted, this would affect the performance of the underfloor heating. So it's new case law that we're now feeding and you know, advising our clients of the implications.
Yeah.
I've put in there asbestos regulations. I mean, the leaseholder or the leaseholder's contractor has an obligation to comply with statutory requirements, compliance asbestos regulations. I have worked with a building where there's extensive asbestos in the common areas and also the flat, so the landlord controlled the removal of asbestos within the individual flats at the time of major refurbishment, and in that particular circumstance the landlord had a retained asbestos contractor that the leaseholder was required to appoint at the time of refurbishment. Building services, the key issues here are overloading of landlord circuits, perhaps extension of communal boiler system, communal heating systems, communal hot water systems, electrical loadings. Common works at the moment include for installing underfloor heating systems. I think generally in small spaces these systems are demonstrated to be okay, but in large scale underfloor heating using electrics, it's possible that the electrical loadings and systems of the building or the flat could be overloaded. Air conditioning, again, quite common. Besides the planning implications, there's obviously an effect on the building. If the landlord permitted installation of air conditioning, what's the implication if every other leaseholder in that building undertook the same alteration? You know, it sets a precedent. Installation of independent boiler systems. I mean, we often work with buildings where there's a communal boiler system, but leaseholders, because of their own requirements, want to install boilers. So the issues there are, how is the contribution towards the upkeep of the communal system dealt with? You know, positions of new boilers, what's the effect on new gas flues penetrating external walls, plumage of vapour, etc. Schedules of condition. This really relates to structural alterations, although in most licences where a comprehensive refurbishment is being undertaken, schedules of condition are usually required. The key ones are usually a flat below or areas below the flat undergoing the works, to record the damage, and, you know, in the case of floods or cracking from vibration. In the case of structural alterations, then schedule of condition may be required for the flat below, flat above, in some instances all the flats in the building. Also, the route for access into the flats, usually a photographic schedule of condition is required, particularly if contractors are using the common areas. Now, this document helps to resolve any disputes over complaints of damage, and as I say to leaseholders, this document really protects leaseholders and landlords or other leaseholders, and it just provides a reference point, as I say, to avoid disputes.
Just touching on the schedules of conditions, is it or would you recommend that it's a good idea for the landlord surveyor to be present when the tenant is undertaking the schedule of conditions, or do you not have any particular views on that?
Yeah, I do have a view. I mean, many years ago, regularly undertook schedule of condition of the landlord's property or other of the leasehold flats. But what I found, and now certain buildings specifically prohibit landlord surveyors from undertaking the schedules of condition, is that in the event of any dispute, it's very well, the landlord surveyor then becomes embroiled in the dispute, and there's an element of bias. So you know, very small alterations, I think it's acceptable, but on large scale developments in particular, I think it's important that the tenant appoints their own surveyor to carry out a detailed schedule of condition. In some instances, this could be undertaken with the landlord surveyor present, but in some other instances, the landlord may then be advised to appoint a surveyor specifically dealing with the schedule of condition, perhaps a party wall surveyor. I've put in access arrangements. Again, a large part of the technical review of the proposals is how the leaseholder's contractor will get access into the flat, how they remove materials and debris from the flat, how they supply materials. In some instances, an external scaffolding may be required. If a scaffolding is required, will that scaffolding be alarmed? We'd usually require a schedule of condition of the areas that will be affected by the scaffolding. What's the implication or the effect of that scaffolding on other leaseholders? It may be that they require, other leaseholders require notices. Scaffolding would generally affect or be an issue that should be notified to the buildings insurers, etc., etc. And again, I work with some buildings that prohibit the use of the common areas, so scaffolding is a requirement of the building for access in and out of the building, in and out of the flat. I then touch on premium payment issues, and Yashmin discussed this earlier. I mean, some alterations have the potential for the landlord charging a premium. Typical alterations are perhaps purchase of a communal loft space, cutting the landlord's structure for works that benefit the flat. So I dealt with a licence probably about a year ago where a leaseholder bought two independent flats and built a new staircase between the flats to create a maisonette. The floor structure was demised to the landlord, so the landlord in that instance charged a premium for the purchase of that floor area so that the staircase could run through.
In terms of those premiums, just to be clear, you don't advise on the level of premiums generally.
No, we don't.
Dealt by with a independent valuation surveyor.
Yeah, that's right. Yeah, we in those instances where a premium payment is to be considered, then it's we would advise that a valuation surveyor is brought in to provide the expertise. Okay, so once we've analysed and assessed the requirements of the scheme, then the surveyor puts together the report, and the report is then circulated, as I mentioned earlier, to the directors, RTM company and the landlord solicitors. I'm not going to go into detail on the report. Again, this will be uploaded as a document, but really the report should be an all-encompassing document that provides the directors, landlord, who may be lay people, with a clear summary of the works, the effect on the landlord structure, what the implications are. The report should then list out the documents that have been approved on a technical perspective, so the documents that may have been modified following the surveyor's review, surveyor's negotiations with the leaseholder. And then the report will cover in detail each of the areas of technical items that I've covered on the last slide. What we do in the reports is we will, for each of the items, so for example, structural alterations, we will describe the works to be carried out, we will describe the information we've reviewed, and then we will include what our opinion is for the terms and conditions to be inserted into the licence. So, for example, as I mentioned, structural alterations, we would always make it a condition that the the leaseholder appoints their engineer to approve the contractor's temporary propping. When Yashmin received this report, if the directors agree with the conditions are then lifted into the licence document and probably put into some legalese wording. So these reports enable the freeholder, the landlord, to consider the proposals and enable the solicitors to then draft up the licence.
It's also a useful tool where, after the landlord or the directors of the freehold company have approved your report effectively, it's also a good time at that stage to then send it to the tenant, because the tenant may not agree or may not be able to comply with all the conditions that you're recommending. So it's at that stage then you have another conversation about the works, possibly another conversation about the works, what the conditions are, whether the tenant can comply, before then it's built into a licence document or a legal document, really.
Yeah,
so
I think that's right.
It's a two-way process, really. So
yeah, I think some landlords prefer for this report not to be sent to leaseholders, but my experience is that the way, depending on the way the report's written, it's actually a good step between the review and the licence, and actually provides a critique and summary of why the terms and conditions have been included.
Yeah, and everyone knows where they stand, really, in terms of the actual licence document.
So when the draft licence is prepared, that comes back to the surveyor, and it is an essential step, really, that the surveyor who prepared the report, who's reviewed the scheme, checks the draft licence. And I've worked before with various landlords where the licence or the draft licence bypasses the surveyor, goes to the leaseholder, it's all signed, and then when we get to site, the provisions that we've put in our report are not included in the licence, and it's it makes the monitoring and the protection of the freehold very difficult.
What happens if the tenant just basically ignores the provision in the lease to obtain landlord's consent? What do they do? Well, they can take the law into their own hands, as we've discussed before, and just proceed without obtaining the landlord's consent. The landlord or the managing agents will probably find out about the works or the structural works that are going ahead at 4 o'clock on a Friday, which is obviously not great for all the parties involved. So they can do that, or what's more common and what we normally see is they will make an application for retrospective consent, and that application is normally made when the managing agents find out that the works have gone or started without landlord's consent, or sometimes the landlord doesn't know that works have been taken part in the building, and it's at the process of the point of sale effectively that people realise. So for example, a tenant may have installed hard flooring and nobody knew about it until the sale particulars come out in the conveyancing process. So there's all different times or at times where retrospective consents will be applied for. If, however, the tenant decides that for whatever reason the landlord's been unfair in refusing consent to do the works or the conditions that have been imposed on the licence, apart from taking the law into their own hands, which obviously is quite risky, the other option is to seek a declaration from the county court that the landlord has been unreasonable in his decision or unreasonable in refusing consent. If the tenant is making those applications, the burden of proof will be on the tenant to prove that the landlord has unreasonably withheld their consent. And that's one of the reasons, if you are a landlord and you've just flatly refused consent, that's one of the reasons why freeholders or landlords should rely on independent advice, so legal advice, surveyor's advice. At least if you are then brought in front of the court or on the wrong end of declaration proceedings, you can then say, well, actually, I did obtain surveyor's advice or I did obtain an engineer's advice in relation to these works, and these are my reasons for refusing consent, or these are my reasons for the conditions that are imposed on this consent. So those are some of the remedies that are available. Moving on to the next slide. Do's and don'ts for landlords. As we've touched on before, the first thing that you should do when you are presented with an application for consent is to check the terms of the lease. It may be that consent is required, it may be that consent is required but not from your client, or it may be that consent isn't required at all and the tenant's application is really not necessary. Once you are satisfied that your client does have to provide consent or some kind of consent or consideration to the licence application that has been made, you are entitled to request further information if the information provided is insufficient. The thing to do if the information is sufficient is not to delay or withhold consent purely because the tenant hasn't provided sufficient information. Deal with what you can and then go back to the tenant and ask for the information that's missing. And I don't know, you are probably in that situation where tenants have provided applications but actually not all the information's there, or you've had to go back.
Yeah, I mean, it really varies. I mean, on larger schemes where the tenant or the leaseholder's got a professional team in place, then usually we've got a good sufficient package. In central London, we're quite fortunate that we generally deal with leaseholders that have perhaps undertaken a refurbishment before, and their professional team are aware of what the licence requirements are. But sometimes we're dealing with a leaseholder who's appointed a contractor that may not be English, may not have any regard to the lease conditions, and provides a sketch that is part of the application. So it does vary, but it's part of our checklist is that we make sure we've got the information that we require, because if the information is comprehensive, then it really speeds up the process. But if that information is drip fed to us over time, then that has a huge effect on the length of time the licence application takes. Yeah, but
from a landlord's point of view, if you have got at least a little bit of information, to deal with what you can really, and then go back to the tenant, put a bit of emphasis back on the tenant to say, look, I can't do anything until you provide this or X, Y, and Z information really. In terms of a decision, it's from a landlord's point of view, you really should be looking to provide the decision as soon as possible. Don't delay in getting to the point of communicating your decision back to the tenant. That just causes a whole raft of issues in terms of proceedings being threatened against you for unreasonably withholding consent because of the delay and all these reasons. So as soon as you're in a position to provide a decision, provide it as soon as possible. And the next point is really to give reasons as to any conditions that are imposed on the licence, or give full reasons as to why refusal is granted to the consent. It just protects the landlord's point of view, and it's the time where you say, look, I've had an engineer review these, I've had a surveyor review these, and in the interest of the freehold reversion or the interest of the building as a whole, consent is refused on the following conditions.
Could be setting a precedent, or
exactly.
etc., etc.
And it goes without saying, act in a timely manner. We have had, I'm sure you have as well, landlord clients that they just don't deal with it. Everyone's got busy lives, or they just don't know what to do with it. if you've got solicitors, if you've got surveyors on board, ask them. Act in a timely manner, because again, from a tenant's point of view, not acting in a timely manner is the equivalent, or nearly the equivalent, of withholding consent, really. And you don't, again, want to be on the wrong end of proceedings in the courts for a declaration being sought against you for unreasonably withholding consent.
Yeah, I think a key thing there as well is the communication. So I mean, I don't think any leaseholder expects a landlord to review a scheme overnight, but I think the part of the problem sometimes where leaseholders don't understand the process is that the application's submitted, then there's perhaps a couple of weeks while the review's taking place, and by this stage the leaseholder has perhaps got a contractor ready to start. And so I think the communication is important, and a lot of that does come from the surveyor, perhaps the solicitor, to say things are being dealt with, it's moving along.
Yeah, and it will also reduce the possibility of works just randomly starting in the block if there's that open communication, or if the tenant does really need to get on with these works. It may be that permission is granted for, like we said at the beginning, soft strip out works. It's communication that keeps it open, really. So do's and don'ts from a tenant's point of view. Again, it comes down to making the application to the right party. Work out who, under the terms of the lease, you should be making the application to, whether it is the landlord, the superior landlord, the freeholder, the management company, under the terms of the lease. And the next point really is key to what you've been saying all along, Gillian, is apply in writing and provide a full application. The worst thing that tenants can do is provide or drip feed information, and it's just going to, if you provide a full package of documents at the beginning, it's obviously going to speed up the process and make everyone's life easier, really, in the whole process. And the last point really is, if you have got any time deadlines for completion, make them known right at the beginning, so everyone knows what kind of timetable they're working to. So just make any timelines known for tenants, really. Right at the beginning, that just helps smooth the process, really. So once the once the licence has been drawn up, the works have been completed, monitoring. Oh, sorry, not completed, but ongoing monitoring. What happens, Julian?
Yeah, so monitoring the works. I mean, in some cases, if the works are very simple, then we suggest the surveyor undertakes at least a sign-off visit, and the sign-off visit really is to ensure that the works have been carried out in accordance with the terms of the licence. Now, for more extensive schemes, the requirement for monitoring may be more intensive. I'm dealing with a rooftop development at the moment, which is a penthouse extension where the landlord has specifically asked us to visit weekly and produce a weekly update report. At the time of submitting our report to the landlord, what we do is make suggestions for what the monitoring involvement should be. I mean, the key thing is to state that we're not checking the quality of the leaseholder's works. I mean, obviously, if we see defects, problems, we'll raise them, but we're not there to oversee the quality of the leaseholder's works insofar as they affect or are confined to the flat. But we are very interested in monitoring the works that will affect the freehold interest. The key things that we like to see, if it's a comprehensive refurbishment, we like to see the waterproofing of the wet areas. There's lots and lots of different systems, lots and lots of different details, and lots of misunderstanding of how to apply these systems from contractors. So on a typical licence, and I mean that in terms of a refurbishment of a flat, keeping rooms where they are, but a full strip out, we'd usually like to see the installation of waterproofing. We like to see the installation of the acoustic insulation for any hard floor finishes, and that's really just to check that it's been installed properly. There's no contact between the insulation and the hard floor finish in the wall. We like to see the structural works, although if it's extensive, that's usually undertaken by the landlord's structural engineer. We like to see that before it's concealed. And really, we can time our inspections that if we're going there to look at waterproofing, we can usually then have a look at whether there are any communal pipes that have been exposed by the works, whether pipes that are to be concealed have been installed using good details. At the time of inspecting the acoustic insulation, the works are generally quite well progressed there. So they're good trigger points. The schedule of condition we've touched on earlier. I mean, the key thing there is if any damage is caused during the works, there's usually a claim from affected leaseholders, and we need to then look at the schedules of condition, assess whether the damage has been caused as a result of the works. The schedules of condition are obviously checked on completion to ensure that all parties are collectively satisfied. When the works have been finished, we then carry out our final inspection, and we produce what we term a sign-off certificate, and there's a PDF copy of this on the uploads. And the sign-off certificate really is again another tick list, just to give the landlord confirmation that we've received, or firstly that we've checked the work and we're happy that it's been undertaken in accordance with the terms of the licence. But then we also check that all of the requirements for documents in the licence have been handed over. So key ones are building regulations, completion certificate, electrical safety certificates, perhaps the gas certificate, gas safe certificate. We ensure that we've got post-installation acoustic reports, so in the case of hard floor finishes. And we package all this information up, submit the sign-off certificate to the landlord, and it's usually at this case that the licence is signed off, any deposit monies for damages are returned.
Yeah, that's right. From our point of view, obviously we don't release any deposits, security deposits that are held until we've got your sign-off and the landlord's happy with your sign-off, really. So.
I mean, just on the issue of security deposits, again, this is usually dealt with in the licence, and it's sometimes difficult because it's quite subjective, and there's not really an exact science for calculating the level of damage deposit. I think we both go on experience, and I think the deposit is there to ensure that there is a little bit of leverage at the end of the licence to ensure that the leaseholder deals with any outstanding issues and provides the documents in a timely manner. But it's also there as a bit of comfort in the case of damage. But we usually make recommendations in our surveyor's report for the level of deposit. But as I say, that's really just based on experience and any conditions of the building.
And also it's down to the landlord's discretion.
Yeah.
Sometimes we've made recommendations and the landlords have either increased it or decreased it depending on how they feel. So it really is the landlord's decision or the management company's decision as to who's granting the licence, as to whether they follow our recommendations or not, really.
Yeah. And deposit monies are held with the landlord solicitors in a client account, I think, isn't it? So
yeah.
On this part of the presentation, what I'd like to touch on is really what can be done to ensure that a building runs smoothly when licence applications are made, when licence works are ongoing on site. And fundamentally, there's a lot of misunderstanding as to what licences are, whether a licence is required, and again, particularly in smaller buildings. Now, my experience from working with managing agents, landlords, directors over a number of years is that having a building manual in place is very key to ensuring that leaseholders know what to do, the licence process runs smoothly, and it really cuts down on all the confusion and really, just guiding everybody, all the parties involved in terms of what they should be doing. So for some buildings, we're appointed to draft licence regulations manuals, and they can be from very simple 2-page guidance notes to, you're contemplating works, here's what you need to do, to 30-page manuals that are very prescriptive in terms of what leaseholders can and can't do. And this document, if in place, should be circulated to purchasers of flats at the time of purchase, so perhaps with the lease documents.
Also in welcome packs and things like that, really.
Yeah, and I think it helps to circulate the document regularly so people are generally aware of what the processes are. And again, on our experience, where those regulation manuals are in place, it just really smooths the process and really cuts down on complaints from leaseholders not really understanding.
The other thing is with these regulation documents, I've found from experience, the shorter and the simpler the document, the better reaction you're going to get from it. We've seen documents which are literally 30, 35 pages, and tenants don't really read that. Contractors, architects don't really read it from start to finish. A smaller document that's simple works, I think, from experience, I think is better really all round.
Yeah, I think, and again, I think in smaller buildings, then really the key things are getting across the requirement for an application and the process, so people are very informed of the process and the potential for timescales.
Yeah,
and I think that document really helps.
Yeah, the key also is to have a good team around you, so the managing agents, the surveyors, the solicitors, all work well together, all know how the other works, and that really is the key to speeding up licenses really as well. Yeah. So.
And I think the document again is used by directors that again may be unaware of the role that they need to perform on the process, and in some cases managing agents. I've had managing agents sort of asking me for what they ought to be doing, and again it's not like an act like the Party Wall Act where there's very specific processes. It's open to how the parties dealing with it interpret the requirements.
And there we have the end of the presentation. Thank you for listening. If you do have any questions or in relation to licences, in relation to the process, in relation to the legal aspects or the surveying aspects, our contact details are on that screen. Or if you want any of Julian's documents, I guess email him. So thank you for listening.
Thanks very much.